I'm Lori Holyfield, and I'm an attorney serving Shelby, Fayette, and Tipton counties in southwest Tennessee. This video is part of a series I'm doing on Tennessee divorce myths that will not die. And today's myth is that children, after they reach a certain age, get to decide where they want to live. This is a pervasive and persistent myth. But children do not get to decide outright where they want to live. They don't get to decide outright what the parenting schedule is going to be. However, as with most myths, there is a grain of truth here, and that grain of truth is that a court does consider a child's preferences. Particularly, the child will consider a child's reasonable preference if the child's at least 12 years old, and perhaps sometimes if the child's younger, if the court decides that that is pertinent and relevant to what's in the child's best interest. But the key here is going to be reasonable. What is a reasonable preference? With respect, I want to live with Dad because Dad lets me stay up all night and eat pizza and play Xbox instead of doing my homework. That's not a reasonable preference. That's not a preference that preserves the child's best interest. However, I'd rather live with Dad because Mom is overbearing and difficult to deal with, and I don't get along with her. May be a reasonable preference given the situation. It's very fact specific, but the court's just going to consider the child's preference, not necessarily go with whatever the child says. It's one of 10 factors that a court's going to consider, and although it can be important and even dispositive in some situations, it isn't always, and it's just not true that a child can outright decide where he or she is going to live or how much time he or she's going to spend with each parent. If you have a question regarding divorce or child custody, please feel free to call me and set up a consultation. You can reach me at 901-388-5190.